Effect of the Woolf reforms. In 2005, The Management of Civil Cases, The Courts in the Post-Woolf World, by Professors Peysner and Seneviratne of the Nottingham Law School, Nottingham Trent, was released by the then Lord Chancellor's Department. The impact of the Woolf reforms was regarded. The findings were that the culture of litigation had changed for the better, with cooperation between the parties improving. There were mixed views over whether the delay had been reduced. Case management conferences were felt to be one of the major successes of the Civil Procedure Rules, CPR. There was a more uniform procedure across the country. There was a very high rate of settlement, often more than 60%, and in some courts over 80%. Part 36 process and sanctions attached to it were found to be effective, although it was felt to be too complicated and difficult to explain to the client. There was little or no increase in ADR and out-of-court mediation. In practice, judges rarely stay cases for mediation, and ADR had not become incorporated into the court process. Costs increased overall as a result of the CPR and the front-loading of costs, with costs in fast-track cases being disproportionate. The courts were still under-resourced and the IT systems primitive compared with those used by practitioners. In 2011, the government stated in its briefing report, Solving Disputes in the County Court, that it was 15 years since the Woolf Report and the framework could not maintain up with the significant economic and social changes that have taken place since then. We agreed that the mechanism has to rely primarily on conflict settlement and debt repayment than on the principles of justice. In fact, they found out that the costs of taking a lawsuit to a trial are sometimes higher than the sum stated. Ideally, disputes should be resolved in the most appropriate forum, so that processes and costs are commensurate with the complexity of the issues involved. They proposed a range of options to achieve this, including fixed costs, already used for traffic accidents under £10,000, to be extended to other personal injury claims for up to £25,000 or even £50,000. Requiring all cases below the small claims limit to have attempted settlement by mediation, before being considered for a hearing. Introducing mediation information/assessment sessions for claims above the small claims limit to try to divert more cases into alternative dispute resolution. Increasing the upper level for small claims to at least £10,000. Applying the rules in court. Case management has contributed to quicker recognition of the problems in litigation, ensuring that further disputes are settled without the requirement for a jury. For several instances, judges have stayed on the court for negotiations. The usage of alternative conflict resolution, ARR, has been allowed by the courts to make expense decisions against anyone that unreasonably fails to pursue the ARR. The judges even specifically enforce the timetables. This is illustrated by Vinos v. Marks and Spencer plc, 2000. In this scenario, the claimants had made the lawsuit just during the time period and only informed the defendant's insurance that they had done so. They were, however, 9 days late in making the allegation on the defendant.